Good evening, ladies and gentlemen. Welcome to tonight's Board of Appeals hearing. Before we begin, let me introduce some members of town government that act as advisors to this board. To my left, Yvonne Friedman. To her left is Rachel Lindberger. To her left is Blaise Donadio. To his left is Jeff Cannon Geyser, and to his left is Sabrina Botia. We're here this evening to seeking release from the zoning board ordinance. New York State statute requires that any town that adopts zoning must also have a board of appeals to act as a relief valve, so the persons can seek relief without the expense of going of legal proceedings. The most common kind of application before this board are area variances. Area variances deal with dimensions of lot area, frontage, height, setbacks, and parking spaces. New York State statute mandates that the board must consider the following 5 criteria in area variances. When you come to the podium, please to present your application, you need to address these 5 areas. They're posted here for you. I think they're over there. Number 1, whether an undesirable change will be produced in the character of the neighborhood or a detriment to nearby properties will be created. Number 2, whether the applicant has other feasible alternatives. Number 3, whether the variance is substantial. Number 4, whether an adverse impact on the environment will be created. And number 5, whether the alleged difficulty is self-created. The statute requires the board to balance the interests of the applicant and those of the neighborhood or community. This statute further requires that the board should grant the minimum variance it shall deem necessary and adequate, and at the same time preserve and protect the character of the neighborhood and the health and safety and welfare of the community. The board has powers to impose reasonable conditions for granting variance. Regarding procedure, cases will be called in order that they are advertised. When your case is called, please come forward, submit your affidavits and mailing receipts to Mr. Donadio, and then you will be given an opportunity to explain to the board why you need the variance. After the applicant is done speaking, all interested parties will be given one opportunity and only one to be heard. Please organize your thoughts, keep your remarks factual that are related to the case, and then I will ask the applicant to come back to the podium to answer your concerns. The board will then close the case and reserve decisions. After all the hearings are closed, the board will review the cases and decide some of them. Others will be reviewed at a later date. There are 3 ways to find out the results of your case. Number 1 can wait until after the public hearing, but there's no guarantee that the board will act on your case tonight. Number 2, you can check the website after 11 o'clock. Number 3, applicants will also be notified by mail. After the hearing is closed, no additional information or testimony can be submitted by the applicant or interested parties. Let me introduce, Simone and Lynn. They are the town attorneys. Blaise is the senior planner in the planning department. Jeff is a planner in the planning department. And Sabrina is with the environmental department. Okay.
Thank you, Madam Chair. The first case on the agenda is case number 19253, Christopher Riley, 116 Oak Avenue, Smithtown. The location of the property is the southwest corner of Oak Avenue and Willow Street. The property is zoned R10. The applicant is requesting variances to reduce the minimum front yard setback on Willow Street from 25 feet to 9 feet for a proposed 15-foot by 30-foot in-ground swimming pool and filter, to reduce the front yard setback from lot line on Willow Street from 10 feet to 0 for a proposed 6-foot vinyl fence.
Good evening.
Good evening.
Can you state your name and your address, please?
Andrew Malguinera, 713 Main Street, Port Jefferson, agent. Malguarnera.
I believe they submitted a power of attorney
We
for you?
did this time, yes.
Thank you. Now, you want to tell us why you're here, please?
Yes, so we're proposing an in-ground swimming pool, average size. The issue here is we're on a corner lot. We only jet a little bit out from the existing foundation line of the house towards the corner. And we're asking for a 6-foot fence on the corner, as most houses on corner lots have, for privacy purposes. My client has small daughters that they just need their privacy. And as you can see, the pool is not is your average size pool. It's not any bigger than normal. Has no effects on the neighborhood. And if the board has any questions.
Gentlemen, are there any questions?
No, thank you.
Planning?
No, thank you.
Sabrina?
No, thank you.
Thank you so much.
Thank you. Have a good night.
Good night.
Thank you.
See if anyone wants to be heard out there.
Is there anyone here who would like to be heard on this application? All right, hearing none, I'll entertain a motion to close the hearing.
I'll make a motion to close the hearing.
All in favor?
Aye.
Motion carried.
The next case on the agenda, case number 19254, Humara Mahdi, 10 Moorwood Drive, Smithtown. The location of the property is the west side of Moorwood Drive, 75 feet south of Dana Lane. The property is zoned R10. The applicant is requesting variances to reduce the minimum front yard setback from 40 feet to 33 feet for a begun prior 84-square-foot front portico, to reduce the total side yards from 28 feet to 25 feet for a begun 34-square-foot first floor addition.
Good evening.
Good evening, Mr. Chairman, members of the board. My name is Carmine Grasso from Cataldo Grasso Architects. Office is at 14 Carl Avenue in Smithtown. I submitted a power of attorney, the mailing receipts, and the mailing and posting affidavits. I represent Humara Mahdi in her request for setback variances for the begun prior construction described by Mr. Donadio. Although the request for the portico is for a 7-foot reduction of the required setback, the actual request is only for 1 foot beyond what would be the allowable encroachment of 6 feet that is permitted in the town code. We feel this is a pretty minor request. The side addition actually meets the minimum side yard setback of 12 feet, but on the other side of the property, the setback is also only a little over 12 feet, so we need the reduction of both side yards, and that's a reduction of 3 feet. The addition was done to square off the building because the original building was actually angled to match the property line on the south side of the building. There's a town recharge basin on that side of the house. With respect to the area variance considerations, whether an undesirable change would be produced, but in the character of the neighborhood, we feel that there isn't. Actually, the portico enhances the appearance of the house, and the side addition, as I said, is adjacent to the recharge basin, so it's not really going to have an effect on anything. Whether the benefits sought by the applicant can be achieved by another method, no, reducing the size of the portico would not provide as much protection from the weather as they would like, and any addition on the side of the house would need a variance. Whether the requested area variance is substantial, we feel that it's not, because both of the encroachments are pretty minor in size. Number 4, whether the proposed variance will have an adverse effect or impact on the neighborhood, the environmental conditions of the neighborhood. We feel that is also no. The additions don't affect stormwater runoffs, sanitary flow, or energy usage. And finally, whether the alleged difficulty was self-created. Unfortunately for my client, yes, because she had hired a contractor thinking that he was following the correct procedure and found out otherwise. She didn't know any of the variances were required, and she thought the contractor had procured the proper permits. So if you have any questions, I'd be happy to answer.
Gentlemen, any questions?
No, thank you.
Blaine, anything?
No, thank you.
Sabrina? Nothing? All right. Is there anyone in the audience who'd like to be heard on this application? Okay. Hearing none, I'll entertain a motion to close the hearing.
So moved.
Second.
Thank you very much.
Thank you so much.
Thank you.
Never mind. The next case on the agenda is case number 19255, Wayne and Karen Berbert, 78 Gannett Drive, Comac. The location of the property is the west side of Gannett Drive, 1,062 feet northeast of Peacock Lane. The property is zoned R15. The applicant is requesting variances to reduce the minimum front yard setback from 45 feet to 37 feet for a proposed 407 square foot front roof over porch, to reduce the minimum side yard setback from 16 feet to 11 feet, to reduce the total side yards from 34 feet to 33 feet for a proposed 499 square foot side addition, to reduce the minimum rear yard setback from 60 feet to 59 feet for a proposed 128 square foot rear addition, to reduce the minimum distance from any lot line from 8 feet to 1 foot for an existing 74 square foot shed, to reduce the minimum distance from any lot line from 8 feet to 0 for an existing 126 square foot roof over masonry fire pit, to reduce the minimum distance from any lot line from 8 feet to 0 for an existing 71 square foot roof over pizza oven, to reduce the minimum distance from any lot line from 8 feet to 3 feet for an existing 9 foot by 40 foot bocce court, to permit an existing 5 foot PVC fence in the required front yard.
Hi, good evening. My name is Wayne Berbert, B-E-R-B-E-R-T. We have our architect here who's going to be presenting on our
Okay.
behalf.
You would like her to speak for you? You would like your architect to speak
Yes,
for you?
please.
Thank you.
Thank you.
Would you introduce yourself and spell your name and your address, please?
Yes.
Thank you.
Good evening. My name is Ashley Lowe Chianese, Chianese, from Mark Anthony Architects. Our office is located at 1563 Belmore Avenue in Belmore, New York. As Mr. Berbert said, I am here on behalf of him and his wife Karen, who are the owners and occupants of the subject property located at 78 Gannett Drive in Comac, New York. We are here today as a result of an application for a proposed rear addition, side addition, proposed front roof over porch, existing roof over masonry fire pit, existing roof over a barbecue/pizza oven, an existing shed, an existing 5 foot PVC fence, and an existing bocce ball court. The front roof over porch and side addition do not meet the minimum front yard setback of 45 feet, having a proposed setback of 37 feet, for which we are requesting relief of 8 feet. Additionally, the side addition does not meet the minimum required setback of 16 feet, having a proposed side yard setback of 11.78 feet, for which we are requesting relief of 4.22 feet. Additionally, the side addition also affects the total side yard aggregate of both side yards. The property is required to have a minimum aggregate of 34 feet, and the proposed aggregate will be just over 33 feet at 33.58, requiring relief of just 1 foot or 0.48. The rear addition requires relief for the rear yard setback, as it does not meet the required 60-foot setback, having a proposed setback of 59 feet, for which we are requesting a variance of just 1 foot as well. The existing shed does not meet the minimum distance of 8 feet to the west lot line, having a setback of 1.4 feet, for which we require a variance of approximately 7 feet, or 6.6 feet to be exact. Additionally, we are looking to decrease the minimum distance to the north property line for both roof overs, the roof over the barbecue and pizza oven and the roof over the fire pit, from 8 feet to the existing 0 feet, which will require a variance for 8 feet. I would like to note that there are no neighbors on this side of the property line. This is Town of Smithtown property. I have provided a photo, there should have been enough for everyone to get, of the aerial view of the subject property. As you can see, there are power lines occupying this area, which makes it unlikely for future residential development. We are also looking to decrease the minimum distance from the south property line from the required 8 feet to the existing bocce ball court, which has a side yard setback of 3 feet, requiring relief of 5 feet. As you can see from the second photo that was provided, the bocce ball court is less than a foot off the ground, so it will not be seen easily from neighboring properties. Our last request this evening is to permit the 6-foot fence that is forward of the dwelling on the north side of the property and is adjacent to the aforementioned Town of Smithtown property. We are requesting relief of 2 feet, as the 4-foot high fence is the maximum allowed by zoning code in an R15 district. I know that there was also a question about the cesspool, and I would just like to read on the record a letter from the Suffolk County Health Department stating that a licensed liquid waste contractor has completed a sanitary system replacement at the subject site in accordance with Suffolk County Department of Health standards. And can I submit this as an exhibit?
Absolutely. Thank you.
That concludes our request. I'm happy to answer any questions.
Gentlemen, do you have any questions?
I just got a couple questions. On the survey you submitted, it appears that a lot of these structures that you're requesting relief on are actually on the, over the property line. It looks like there's about a 3 to 4, almost 3.5 foot encroachment where the roof over seating, the planter, and the barbecue are. Are you aware of that?
Yes, on the north side of the property line where the planters are. Yes,
So-
we are aware of that.
We can only grant to 0. We can't grant over the property line. So those encroachments would have to be brought back onto the applicant's property.
There's no way that the Town of Smithtown can provide some sort
No,
of,
this board can't. This, you know, this board can only grant for your property. We can grant to 0, nothing past it. You know, if you wanted to try and enter into an agreement with the town board, it looks like there's a Long Island Lighting Company easement there as well. I'm not even sure if it is Town of Smithtown property.
so we did go back and forth with the Board of Zoning Appeals. They had provided us with a radius map that showed that it was the property of the Town of Smithtown for the section block and lot. But if all you can offer is for 0 feet, then,
Yeah, we don't have the jurisdiction to go any further
Okay.
than that.
Blythe, did you,
Thank you.
Sabrina?
Madam Chair, our comments were as well regarding the encroachments onto what is a existing town recharge basin and a town drainage easement, and we recommend that they contact the Highway Department regarding the encroachments.
Yeah, okay.
we can reach out to the Highway Department tomorrow.
All right.
Do you guys have any other questions?
No, I think that's fine. Let's see whatever, you know, if anyone in the audience wants to speak.
You got it.
Is there anyone that would like to speak on this application? Okay. Hearing none, I'll entertain a motion to close the hearing.
So moved.
All in favor?
Aye.
Aye.
Motion carried.
Thank you.
Oh, sorry.
Is it-
The next case on the agenda is case number 19257, Coram Deo Church, 4 Seashell Lane, Fort Salonga. The location of the property, the north side of Seashell Lane, 1,137 feet northwest of Marion's Lane. The property is zoned R43. The applicant is requesting variances to permit environmentally sensitive lands to be altered where depth to groundwater is equal to or less than 10 feet, to reduce the minimum lot area due to environmentally sensitive lands from 43,560 square feet to 0, to increase the maximum permitted gross floor area due to environmentally sensitive lands from 20% to 100%, to permit construction of a structure from any wetland, escarpment, natural water feature, or significant wildlife habitat from 100 feet to 46 feet, to increase the gross floor area of a lot within the LWRP from 0 to 5,770 square feet for a proposed 1,361 square foot two-story addition and proposed 95 square foot second-story balcony and existing masonry pavilion.
Good evening.
Good evening, Madam Chairwoman and members of the board. My name is Michael McCarthy. I'm an attorney with offices at 444 New York Avenue in Huntington, and I'm here this evening representing the applicant, which is the Coram Deo Church. The Coram Deo Church, Madam Chairwoman, is a Christian-based church. This particular chapter is located in New York City, and they bought the property in question in 2021. Coram Deo translates to in the presence of God, and they use the home as a retreat for their congregants. I thought it would be important just out of the gate, and maybe the board was curious as to why a church owns it and what they do there. This particular home is used just for quiet retreat, quiet contemplation. Pastor Kim, who's with me, he's the pastor of this particular of the New York City-based Coram Deo Church. And I also have with me Peter Smith. He would be the contractor who would build the addition if the board grants the relief that we're requesting. And I have with me Nick Pfluger, who is the architect. But I wanted to, I guess out of the gate, Madam Chairwoman, because I would be curious as to what Coram Deo means and why they bought it and what happens there. But they've owned the home since 2021. They've used the home, without incident. I've got letters from the neighbors. They're a very quiet neighbor because of the contemplative nature in which they use the property. What we're proposing tonight and what we're asking permission is for a modest expansion of the home that would accompany a renovation. If your pictures depict, and if you're looking at any Google Earth images of the home, the house was built in 1984. So it's 45 years old. Lost 20 years there, madam. Mm-hmm. It's 41 years old. And of course, it's on the bluff, and it's an environmentally sensitive area. It takes the weather. The windows, the siding, and everything, have really, caused, some, age to the structure. The proposal is to provide an expansion, which would all be within the conforming setbacks in the building code zone, but of course the property is located in an area designated as environmentally sensitive land and is also in the LWRP zone. So the plans reflect what we feel is a modest first floor extension of 745 square feet. If you look at the plan, it's actually maybe a foot or two less. I think it really scales to 743, but as applied for and as denied, 745 square feet, with a second floor addition of 616 square feet. The plan also reflects, a modest, 95, square foot balcony, which would be on the second floor addition. The addition would accommodate 2 bedrooms and 2 bathrooms. As part of this, renovation and upgrade, if the board grants the relief, the sanitary system would be upgraded as well under Suffolk County Department of Health Services regulations. This board is very familiar with the new sanitary system, which helps with nitrogen intrusion, especially in an environmentally sensitive land. It's something that the town would hope to achieve. I need to believe, and I don't know this for fact, that the sanitary system there is probably, the original, and it's antiquated by today's standards. We tried to give thoughtful consideration as to how the expansion would take place. This expansion of the home, because we're in the environmentally sensitive property, would be on pylons. Now, the home was built before there was regulations that were put into place by the town of Smithtown, so it has a traditional foundation. The board might be familiar with an application that came before this board a few years ago for the house that's, I think, nearing the end of construction next door, by our neighbors who gave us a letter in support, the De Gregorios. And if you look at an old Google Earth image, you can see a traditional foundation. And I questioned why it would be that the new home would have pylons where the home next door was on a traditional foundation. And, Blaze would be able to explain to you that the difference is that this home that is in question is in the FEMA zone that's known as a VE zone, and the line kind of comes on a curvature along the coast, and the house next door at 3 Seashell Lane is in an AE zone. Different standards that apply by FEMA, so it's designed to comply with FEMA regulations. It's designed to comply with Smithtown building code regulations. We did submit as part of the application a New York State DEC letter of non-jurisdiction. We put an application in for the LWRP. I did get a letter just last week from the Department of Environment and Waterways requesting follow-up information. There was 3 items. We, supplied answers to both of them, to 2 of them. I still think there's one more outstanding regarding a test hole information. That's really the essence of the application, and I'll go through the 5 standards, but I do have letters that I'd like to hand in. I had asked my assistant to previously transmit them by way of electronic communication to the board.
I think we do have those letters.
It's a
on the
letter
record.
from Jason and Audra De Gregorio.
Yes, we
and
have
it-
that.
Okay, and there's another letter
Yes.
from Charlie and Tia Muller.
We have that too.
Yes, I don't know if Charlie Muller's in the audience, but I haven't seen him in ages in any event. So, Madam Chairwoman and members of the board, if you have any questions regarding how the home was designed, I've got Nick Pfluger with me, he's the architect. If you have any questions regarding how the home would be constructed, I have Pete Smith, he would be the contractor. If you have any questions regarding Coram Deo and what they do, I've got Pastor John Kim with me. He runs the show, and I think by all accounts, a good neighbor, bought the home. It's a stunning setting. I think this board knows it's a really, sought-after area of Smithtown. I'm very lucky to be there, and to have it and enjoy it. And they'd like to renovate it. They'd like to clean it up and renovate it, and maybe bring it back to its original grandeur. So, that being said, are there any questions before I address the 5 elements of the?
Gentlemen, do you have any questions?
No, other than I believe we received a letter regarding a dam that has failed. Is that on this subject property?
I don't think so. No, I'm not aware of it.
Okay.
Yeah. Would you have a copy I could take a peek at, just to be
Yeah,
sure?
this is all part of the record, right? Well, this one's from our bank. You can have mine, it's fine. You want me to read it in?
Could I just take a quick peek at it? Do you
Yeah,
mind if I
sure.
approach?
Why don't you go back to, they can use the microphone if you need to.
Thank you for giving me a moment to confer with my colleagues here, my professionals. It's the first we're hearing of it. I don't know for a fact that there's a dam on the property. I think it's a dam that you access by going through the property, and I think the concern expressed was, you know, I guess the construction of new homes and bigger homes and things of that nature, you know, might have a compounding impact. I would point out, in response to this communication, which I haven't really had time to digest, is that I think the board knows that in accordance with building code standards, you always try to upgrade the standard that didn't exist 41 years ago, the retention of stormwater runoff and things of that nature. I think the board can be assured that during the building construction and the building permitting process, if the board grants the relief we are seeking, that they will be adhered to. If you would like us to, maybe somebody from planning can, you know, email me a copy of this communication. And what we can do is we can reach out to the author of it and the Siegel Point Association and find out what their concern is. I can assure you that if there's anything that the Siegel Point Association requires by way of access or contribution to help mitigate any issue that's happening, Pastor John Kim and the Quorum Deo Church will cooperate,
Thank you.
if that's satisfactory.
Blaze, did you want to?
I would just let the board be aware, and Mr. McCarthy be aware, that the planner in the planning department who does all of the LWRP reviews and creates the consistency determination for the town board to adopt, received a copy of this, so he'll be reviewing it, and I'm sure they can make a determination whether or not the information in here is pertinent to the application.
And I would, thank you, Blaze. And I would add to what Blaze was indicating, we will certainly cooperate. If they need some help, we're there to help. If they need access, we're there to access, you know, property, so.
Okay, thank you. Sabrina?
Yes, Madam Chair. As Mr. McCarthy has said, due to the presence of high groundwater on the property, we have notified him that the submission of new test hole data that within the past 6 months is required for us to complete our environmental review, as well as we will need the LWRP approval from planning before we can proceed with our environmental review. Therefore, no decision will be made until those items are addressed.
So you know there'll be no tonight.
Understood. We didn't have an expectation there would be a decision tonight. And Sabrina, we supplied, I think, the
Yes, I
DEC letter.
received them.
Yeah, and
Thank
just so you know, Suffolk County Soil Evaluations, they're located in Mattatuck, and we've contacted them for the soil borings. As soon as we get them, we'll give them to you.
Thank you.
Thank you.
Thank you.
Do you feel there's any need for me to bring the architect and the builder forward to talk about
Thank
anything?
you. No, thank you.
Okay, so
Yeah.
I just to be clear about this, to go through the 5 elements of an area variance under the New York State Town Law, we feel that if the board grants the application, it's not going to cause an adverse impact upon the character and value of adjoining properties or otherwise cause a devaluation of adjoining properties, because we feel that it's modest in keeping, and in fact, in actuality, it should help buoy and support the value of adjoining homes, because you don't want to see the house fall into disrepair, and you want to see it modernized. And I hope that the board will appreciate that the requested relief is fairly de minimis to the size of the house which exists overall, which dovetails into the second element as to whether or not the requested variance is substantial. And when the board makes these determinations of the substantial nature of relief, you always weigh it in relationship to what you have versus what you proposed. And again, you know, we respectfully submit that a first floor footprint expansion of 745 square feet in relationship that the fact that it meets side yard setback, that the board would find that to be not substantial. The benefit that we see can't be achieved by any other means because the entire property is designated as environmentally sensitive wetland. It's already been disturbed, it's already been developed, and again, I hope the board would find and recognize that it's a modest expansion in relationship to what exists. It won't cause any adverse environmental impacts for several reasons, not the least of which is that it will be constructed in accordance with town building code standards in an environmentally sensitive area and in accordance with new FEMA regulations. And last but not least is whether the difficulty was self-created. The difficulty exists as a function of the regulation that was imposed if the board remembers its history or wants history about it, this ordinance came into effect, I believe, in 1989 for the first time, and of course, the home had been built 5 years prior. So in any event, the ordinance came after the house, and the house is there, and we hope the board recognizes the need and the desire to upgrade it.
Thank you.
Thank you very much.
Is there anyone here that would like to be heard on this application? Yes, sure, come on up. I'm going to ask you to state your name and spell your name and your address, please.
Good evening, first of all. My name is Kevin Burke, B-U-R-K-E. I live at 77 Fresh Pond Road in Fort Salonga, New York, and I am the president of the Seagull Association, which owns the property that immediately borders on the west side of the applicant's property. And I have two concerns. First one is obviously the environmental concern that will affect the waterway and Fresh Pond itself. Fresh Pond is created by a dam which is on the property in question. I have met with the Suffolk County Parks Department, which owns most of the pond. I have met with the DEC from the state. I have met with town councilmen from both Smithtown and Huntington, since the pond is on both sides of the border. And they've all assured me that the dam is on the private property that is in question. And therefore, they have no responsibility to maintain or repair it. That has to be done by the homeowner. The application for the repair has to be submitted by the homeowner. And then the DEC will tell them exactly how it should be repaired and grant them, hopefully, a permit to do it. The association is not looking for access on his property to fix his dam. I think that's, understandable. I've also submitted a survey map that does not show the dam, unfortunately. It shows everything but the dam. I have submitted an aerial photo that does show the dam. I have given you pictures of both the dam and the runoff water from the dam that comes from the pond out to the sound, and the deplorable condition it's in. It's not being maintained, it's not being cleaned or addressed, and this is an ongoing problem. I have met with Mr. Kim on a couple of occasions over a year and a half ago now, asked him about the dam and what we can do about it and all, and basically he said, he'll chip in. He'll chip in to repair his dam. We don't find that acceptable. We don't find that reasonable. The other concern I have with the property is what its actual usage is going to be. I've been there for 7 years, longer than Mr. Kim has. In the 3 to 4 years that he's owned it, I don't think they've spent more than 5 or 6 nights a year there. The house has hurricane shutters on the sound side, and I don't think anybody would be staying there and leaving the shutters down. The neighborhood realizes that it's owned by a church in the city, probably for tax reasons. He wants to put an extension on it. Why, I don't know. If this is to bring in strangers from the city for retreats and allow them to utilize the house and all, and possibly even incur a charge for that, I don't think that's the proper zoning or usage of that property. But most concerning is the fact that if the dam is not repaired, the water will escape out of the pond, which is about a 30-acre pond, and all the houses around it, which include some 40, 50 homes at least, will be financially affected by their values because it'll turn into a mud flat, and it'll, just will not be desirable, so.
Thank you very much.
Okay.
Thank you so much. Is there anyone else that would like to be heard on this application? Anyone else? Okay. Would you like to come back and answer his concerns, please?
So in the intervening time, I did have a chance to look at the survey of the property more clearly. And I apologize if Mr. Burke didn't understand that Mr. Kim maybe didn't understand the nature and extent of what it is. The dam in question is reflected on your survey as a head wall. And I don't know that he being Pastor Kim and the church that owns the property understand that structure is on their property and owned by them exclusively. I can represent to the board, having consulted with Pastor Kim, that if the head wall is in fact in need of repair or replacement, that they will undertake to do it. Nobody wants to see any kind of environmental catastrophe going on. The integrity of Fresh Pond is unique to the property as it is unique to the community. So I can make that representation. I can ask Pastor Kim to come up and make it to you if you'd like. But I don't know that's really a function of the application that's before the board tonight. It's really much more of a public declaration that we recognize that the head wall, Mr. Burke calls it a dam, is located on private property, and we'll look into it. You know, but the first I'm hearing about it was the letter. The second aspect, and I don't really feel that I should have to delve into it more deeply than I did with the opening remarks. You know, how people use their property, as long as they're using it respectfully and peaceably and in conformance with the code, you know, really isn't the concern of anyone else. As I indicated, maybe Mr. Burke didn't hear the remark, but it's a Christian-based orthodoxy, and they're quiet, and the neighbors like them, and provide you letters. So I just give you the assurance that if I hear from Sabrina or if I hear from Blaze that we need to do something, as it goes with this LWRP application, we'll definitely take care of it. All right,
you so
and I thank you.
Okay, I'll entertain a motion to close the hearing.
So moved.
All in favor?
Aye.
Aye. Motion carried. Thank you so much.
We have like 50 of them.
Yeah, we don't.
The next case on the agenda, case number 19258, Michael Lally, 16 Byron Road, Comac. The location of the property, the west side of Byron Road, 520 feet north of Ramsey Road. The property is zoned R10. The applicant is requesting variances to reduce the minimum setback of a 6-foot retaining wall from the property line, excuse me, from 6 feet to 0 for existing retaining walls A and B, to reduce the minimum setback of a 6-foot fence from a 6-foot retaining wall from 6 feet to 0 for existing walls A and B, to increase the height of a 6-foot fence on top of a 6-foot retaining wall from 6 feet to 12 feet for existing walls A and B, to reduce the minimum setback of a proposed 5-foot retaining wall from the property line from 5 feet to 0 for wall C, to reduce the minimum setback of a 6-foot fence from a 5-foot retaining wall from 5 feet to 0 for wall C, and to increase the height of an existing 6-foot fence on top of a 5-foot retaining wall from 6 feet to 11 feet for wall C.
Good evening.
Good evening, Madam Chair and the board. I'm going to go ahead and let Carmine speak
So
on.
let me,
I'm Michael Lally at 16 Byron Road.
thank you. And you would like it,
Yeah, I'm going to let Carmine speak on
Please,
behalf of the
thank you.
matter before the board. Once he's done, I just have a quick question about the right side retaining wall.
Okay.
Once he's done, all right?
sure.
Good evening, Madam Chairperson, members of the board. My name is Carmine Grasso from Cataldo Grasso Architects, office at 14 Carl Avenue in Smithtown. I submitted the mailing receipts and the affidavits. I represent Michael Lally in his request for variances for retaining walls and fences for a pool that has existed on his property since at least 1978. I submitted some aerial photos of the property dating back over the years, so you could see that the pool has been there all those years. The walls are located at the property lines due to the location of the pool on the property. This is done to maximize the usable area in the rear yard, and because you have to have, obviously a certain flat area around the pool for the paving as well. The fences are atop the retaining walls to allow for some room to get around the pool, and also, again, to maximize the utilization of the backyard for my clients. So, in regards to the area variance considerations, whether an undesirable change would be produced to the character of the neighborhood or detriment to nearby properties, we feel that it won't. The walls that are there now are replacing existing walls that have been there for many years. Looking back at those aerial photos, it looks like at least till the clearest ones you could see go back to like 2001, and those walls there were walls on the property. They've been replaced since. So we feel that the walls actually help the stormwater runoff from going on to the neighboring properties, as my client's property is higher than all of the surrounding ones. And they're replacing walls, and there is one wall on the right side of the property, which would be the west side, I guess the northwest side, that the applicant is putting up a new wall because the existing wall had been removed, and he wants to maintain the integrity of the pool and the paving around the pool, because that's actually pretty close to the side yard setback there. Whether the benefits sought by the applicant can be achieved by some method feasible, no, this is the only way to keep the rear yard level and usable for the applicant, and it's necessary to have it level for that swimming pool that's been there for nearly 50 years. Whether the variance variance request is substantial, we feel it's not substantial, mainly because they're replacing existing walls and fences that have been there for decades. Number 4, whether the proposed variance would have an adverse impact on the physical or environmental conditions of the neighborhood. We feel that it won't. The walls aren't going to affect any sanitary flow or usage, and they help maintain stormwater runoff, as said earlier. And finally, whether the alleged difficulty was self-created, we feel that it wasn't, because he's working with conditions that existed prior to the current setback regulations for walls and fences. So if you have any questions, I'd be happy to answer.
Thank you. Gentlemen, any questions?
No, thank you.
Blaise?
No, thank you.
No,
Sabrina?
thank you.
Okay. Is there anyone, you would like to
Yes.
make a statement? Yes.
Yeah, I'm just looking for clarification from the board and from the council regarding the right side retaining wall. My predecessor had replaced that wall a couple of times. When the work was done in the backyard, it was therefore removed by the next door neighbor. And I'm just looking for clarification from the town to see whose responsibility it is to maintain the wall. I totally understand if it's my responsibility to maintain the wall, but if it was removed by me and to go ahead and replace the wall, if it was not removed by me, does that land on the shoulders of the person who did therefore remove the wall?
It's your wall, it's your responsibility. I don't believe you're required to have a retaining wall.
No, it's not that I'm required. I'm looking like I understand
Yeah, but-
that I'm not required to have the retaining wall. It's my responsibility to maintain it. But does that mean my neighbors can go ahead and remove the walls at will, and then I have to go ahead and replace them? Okay, so if it's on my property, it's my property. It's mine.
Yep.
So, said neighbor who removed the wall is out of line and out
I'd
of
ask,
place.
I'd ask your attorney.
Okay. All right. Thank you.
You're welcome. Is there anyone that would like to be heard on this application? Come up, please. You. Are you going to speak?
Good
Good
evening.
evening. May I have your name and address, please?
Tom Mazzola, Mazzola, 20 Byron Road. I'm actually here speaking on behalf of Ms. Murphy, who lives at 18 Byron Road, next to the property in question. And they're actually here based on a dispute that has been going on between the two neighbors. The previous owner of his property had built a retaining wall that encroached on Marta's property. When he was rebuilding his whole yard 2 years ago, he knew that. She reminded him that she didn't need the wall. The wall is holding up his property. Her property is lower. That he should replace the part on her property, which is wall C on your plan, because the retaining wall that the previous owner had put up was rotting. He refused to do it. He built walls A and B, which are 6 feet high, but he did not build the wall on his side. Now he's trying to say she shouldn't have removed the wall. It was on her property. She doesn't need it for anything. And you can see his architect drew up a plan that shows a wall on his property line, which is wall C. She's not opposed to this application. She wants him to build wall C on his property to hold up his patio and his pool. That's all she's looking for, and he hasn't done it. The only reason he's here is because the town inspector finally listened to her complaint and issued him a summons for doing all the work without a permit. If you approve it, and again, she doesn't object to the variance, even though it's a zero setback on her property line, she's willing to accept that with a 6-foot fence on top of it. She wants to make sure that it's done in a timely manner, that he doesn't drag it out. She's been trying to get this done for 2 years. She wants to make sure that it's built on his property, not encroaching on hers. She wants her property restored, because they're going to have to work on her property to build this wall. His patio is on the other side of the fence. The only way they can do it that I can see is coming up. She's going to have to let them come on her property. She wants to make sure that it's cleaned up and restored when they're complete. She would like those as conditions of any approval that you give.
Good evening, Madam Chair.
Yeah, state your name again.
Marta Murphy, M-A-R-T-A, M-U-R-P-H-Y, 18 Byron Road, Comac. I've been at this home for 33 years, and very peaceful neighborhood. Nobody, gives anybody any problems, whatever. This gentleman here moved in February 2021, and actually has been a menace since he moved in with loud okay, forget it. All right, so anyway, he has been harassing me for the last year and a half. So, my dog, my home, and myself. Again, like Tom mentioned, that I would like a deadline because he always prolongs everything. And I never reported him in the sense for the inspector to come and get him. I told him he needed a wall. I didn't, it was on my property. I told him he needs his own wall. He did the other sides, but he didn't do my side. So he wanted me to pay for the wall. I don't need a wall. It was all rotted. I had to cut down, although I left the back portion because it was higher ground, because I'm not there to cause damages to his property. In fact, we had so many torrential rains in 2023 that his dirt started to come down and whatnot, and I put up plywood up against the fence. I've been looking at it for the last year and a half. I would like to take that down now. And then he has to follow through and put his wall that he needs to sustain his pool. What else can I say? Now, if I take down the plywood now, because honestly, summer's here and it's been there for a year and a half, will I be held liable for damages because his dirt's coming down? That's, I feel, by me taking the plywood away is just going to make him move along faster, as long as I'm not going to be held liable. The previous owner of 16 Byron Road, his wall was rotting, okay? So I told them to replace it, but they didn't have the money. It was an older woman and the son, and they didn't have the money to raise the fence. So then I said, can we put it on this side of the fence? So kind of like what I guess he's asking for, right there by the property line and the fence. They put it on my property, okay? But he knew what occurred. And I told him when he first moved in, when we met, I said, listen, you got to put up your own wall. And he never did. And he redid his backyard, and then he said, well, what you did for them, that's on you. Okay, so that's all I have to say, ma'am, and members of the board, is that I've been there 33 years with no issues with anyone, and, you know, it's just unfortunate that this happened.
Okay, thank you so much.
Thank you.
Come on. You want to say something?
Is there anyone else?
Wait a minute, was there anyone else that wanted to be heard? I don't think there was.
Just for the board's knowledge, I was not given a summons for any of the work I did on the property. I've been working close with Mark, the inspector, and for his recommendation, I was to not build a wall until we had proper permits in place. I was told to wait by the inspector. I have not been dragging my feet. I've just been waiting for the proper permits in order to go ahead and replace this wall.
Is this wall on your property?
As far as the survey shows, yes, it is.
The new wall, the one you're proposing.
The one-
Well, that survey should be drawn with the old wall intact. Where was the old wall?
I'm sorry, you cannot speak.
I don't see an old survey. I only see the one with the proposed.
That survey was taken with measurements from the portion of the wall that she left up. So it should just be drawn out in a straight line.
So this back portion is what she left on?
A small portion, maybe about 5 feet. So I'm assuming the,
If it helps, I could clarify the location of the wall on the plan. Obviously, as the board knows, we cannot apply for a wall on the adjacent property, so we had to show that the new retaining wall was going to be on the property line and then request the variance for the 0 setback. So it's not showing any remains of an existing wall there for that reason. So-
Question for you.
Yeah.
We know that it's impossible to build a retaining wall on a 0 setback without affecting the neighbor's property. In the interest of being neighborly, how do you propose you're going to do that?
as long as Mrs. Murphy's willing to be cooperative, I will have guys come and do whatever the necessary work is to make sure the wall is as close to the fence as possible. During the dispute, we had a survey company come and draw the property line. When we did that, it was pretty clear that the property line was to the right of the wall, going all the way down the property. So I don't have any of that information with me. That was all given to lawyers and stuff like that. But when that was going on, the wall was on my property.
Okay. Thank you.
Okay. Anything else? I'll entertain a motion to close the hearing.
So moved.
Moved in second. All in favor?
Aye.
Aye.
Motion carried.
Thank you.
The next case on the agenda is case number 19259, Lisa Tersalino, 10 Thomas Drive, Hauppauge. The location of the property, the west side of Thomas Drive, 310 feet north of Town Line Road. The property is zoned R10. The applicant is requesting a variance to reduce the minimum rear yard setback from 50 to 34 feet for a proposed 348-square-foot portico with outdoor kitchen.
Good evening, Lisa Tersolino, 10 Thomas Drive, Hauppauge, New York, and my architect will be speaking on my behalf.
You speak for- yeah.
Good evening, Madam Chairman, members of the board. My name is Michael Morbillo, architect. My firm is Nspire Design Group. My office is located at 273 Lake Avenue in St. James, New York.
Okay. Want to tell us why you're here, please?
Yes, the application tonight is for a 348 square foot rear portico. It's a one-story structure, approximately 15 feet in height. It's an open structure with columns. Basically, it's being used for outdoor lounging on their existing patio that they have right now. In essence, it's an accessory use to the building. The reason we're before the board is a little bit due to the uniqueness of the property. This property is part of an overall subdivision of Gray Rock Estates, which was filed in April 24th, 1967. There's about 20 lots in the subdivision. On average, most of the lots are about 160 feet deep. There are a couple of lots that are located on cul-de-sacs. And because of the radius of the cul-de-sacs, you can see whether it's through an aerial or anything else, we happen to be one of like two shorter lots in the neighborhood, where we're measuring from is about 130 feet on the north property line. So we're a little bit smaller envelope. So therefore, we don't have too much space to work with. So we're basically requesting, it's about a 32% reduction in the rear setback from going from the 34 feet to 50 feet. That's just kind of under substantial request. Also, just to make a note, again, it's an accessory type of use of property. Not that Smithtown has great zoning laws. In neighboring towns like such as Brookhaven, they consider accessory setbacks for this. But just as a reference that this will never be an enclosed. So if there's ever a condition, the board is considering this application, we would accept the condition that the structure never be enclosed, that there's never a second floor or anything put on it, that it remains with the proposed design. Certainly, the structure is not going to have an undesirable change in the character of the neighborhood. It's located in the rear yard. It will not have an environmental impact due to its size and its openness. As I mentioned, they don't really have any other place to do this, and due to the lot configuration, and it's not a substantial request. And lastly, an argument can be made that the matter wasn't self-created because they happen to be on one of those 2 out of the 20-some-odd lots in the subdivision that would just happen to be, on average, smaller than the remainder. So if the board has any questions at this time, I'd be more than happy to answer them.
Gentlemen, any questions?
No, thank you.
Blaise?
No, thank you.
Sabrina?
No, thank you.
Okay. Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved.
Really, second, all in favor?
Aye.
Motion carried.
Thank you. Have a good evening.
The next case on the agenda is case number 19261, Anthony Saccone, 58 Darling Avenue, Smithtown. The location of the property, the south side of Darling Avenue, 628 feet west of Hauppauge Road. The property is zoned R10. The applicant is requesting variances to reduce the minimum side yard setback from 12 feet to 3 feet, to reduce the total side yards from 28 feet to 19 feet, to permit accessory structures in the required side yard, 4 existing 82 square foot and 52 square foot sheds.
Good evening.
Good evening. My name is Carlos Munoz from Todd O'Connell Architects, 1200 Veterans Memorial Highway. We submitted a power of attorney.
Yes, we have that. Thank you.
So we're here for to be able to maintain 2 sheds that are currently on the property. Unfortunately, because of the building envelope, they're considered to be part of the side yard, but in fact, they're over 30 feet away from the house. The shed in question, one of them is really, you can see in the photographs, it's just a wood storage rack. It's not even a full shed next to the other one. I know one shed is allowed to be with 2 feet from the property line, but again, it doesn't apply here because of being part of the building envelope. Yes, the applicant did cause this issue by building it without a permit, but I don't think it's substantial in any way. They use it for obviously the fire pit, and moving it away from the house even further than that would probably be would not make sense to even have it. It's hidden behind the other shed as well, so it's a perfect spot to just hide any messy wood that you could have. You could even see it from any of the neighbor's property. The property is highly screened, and it shouldn't affect any neighbors or affect the character of the neighborhood in any way. Doesn't really cause any also environmental issues. If you have any questions.
Okay, we'll ask. Gentlemen, any questions?
No, thank you.
Liz?
No, thank you.
Sabrina?
No, thank you.
Okay. All right, hearing none, I'll entertain is there anyone in the audience that would like to be heard on this application? Okay, yeah. I'll entertain a motion to close the hearing, please.
So moved.
All in favor?
Aye.
Aye.
Motion carried.
Thank you.
The next case on the agenda is case number 19263, Deborah Robinson.
Hi, good evening. My name is Deborah Robinson, R-O-B-I. Oh, sorry.
We'll let him read the, okay,
Thank you for your enthusiasm.
that's okay.
110 Midwood Avenue, Wisconsin. The location of the property is the west side of Midwood Avenue, the east side of Heritage Place South. The property is owned R15. The applicant is requesting variances to reduce the minimum front yard setback on Heritage Place South from 45 feet to 18 feet for an existing 1,535 square foot, 2-story detached garage. To reduce the minimum front yard setback on Heritage Place South from 45 feet to 0 for an existing 6-foot PVC fence. To reduce the minimum side yard setback from 16 feet to 0, to reduce the total side yard setbacks from 34 feet to 6 feet for an existing 1,535 square foot, 2-story detached garage and existing generator. Increase the square footage of an existing detached garage from 750 square feet to 1,535 square feet. To increase the maximum height from 15 feet to 18 feet. To reduce the minimum distance from any lot line from 8 feet to 0 for the existing detached garage. To reduce the minimum distance from any lot line from 8 feet to 2 feet for the existing generator.
Okay, now, may I have your name and address?
Yes. Hi, good evening. My name is Deborah Robinson, R-O-B-I-N-S-O-N, at 110 Midwood Avenue, Wisconsin. I'm having my architect represent me tonight.
Yeah, fine. If you would give us your name and spell your last name and your address, I'd appreciate it.
Absolutely. Good evening, Madam Chair, members of the board. Michael Rubenstein, R-U-B-I-N-S-T-E-I-N, architect for the applicant. Our offices are at 1070 Middle Country Road, Suite 7, Selden, New York, 11784. So we're here before you this evening to request several area variances. We're maintaining the existing detached garage and the generator. Each are requiring the several variances from this board.
During an inspection for an open work permit number 231275 to repair the fire damage, the inspector brought to our attention that the garage and generator did not have permits or certificates. My client's family purchased the house in January of 1988. The garage was existing at the time of their purchase. It is approximately 1,500 square feet. We have pictures of the exterior and the interior. I have supplemental pictures that I can present to the board. I also have 4 letters in support of the application and a survey from roughly 1988.
Thank you.
Okay. At the time of the purchase, Heritage Place South did not extend beyond my client's property. It terminated at the northern property line, as evidenced from the survey I just submitted. It is our understanding that Heritage Place South was extended to the south when construction of the dwelling located at 40 Heritage Place South began. The extension of Heritage Place South therefore created additional variances from the front yard setback relief that we are seeking tonight. The generator was installed sometime in 2011. Concerning the 5 considerations of a variance, I offer the following. The variance would not produce an impact on the adjacent properties or the neighborhood because the existing detached garage predates my client's ownership of the property. It appears that the garage was built sometime around the time of the house was constructed in 1923. The generator was installed sometime in 2011 by my client's parents. To our knowledge, no one has complained about either structure. The request is not substantial because it appears that the garage was constructed prior to Heritage Road South being extended, and therefore the extension was causing the relief sought here, some of the relief sought here tonight. The benefit cannot be achieved by any alternative. The benefit cannot be achieved by an alternative because the existing garage predates my client's ownership of the property. It has existed since the time of the house was constructed, about 1923, and we're not aware of anybody taking issues with these structures. The variance would not cause an adverse effect on the environment because the structures are existing and no work is being proposed. The difficulty was not created by the applicant or a former owner because the extension of Heritage Place South was completed after my client's purchase of the property, therefore creating additional variances. We have 4 letters of support. One is from Mr. Wolf, 40 Heritage Place South, Ms. Rosanna Sabini at 112 Midwood Avenue, Ms. Lori Antonazio at 30 Heritage Place South, and Ms. Dana Marfagolo at 6 Crusader Lane. Based upon the information provided and the survey from 1988, photos of the structures and letters of support, we do not believe the granting of this application will be detrimental to the neighborhood. If there's any questions from the board, I'd be happy to answer.
Gentlemen?
Yeah, a couple questions. Sure. I'm looking at the survey and the pictures that you submitted. It does look like there was a garage there, but it's not the garage that I see in these pictures. Was there an addition, subsequent additions made on this garage?
No, it's the same garage.
The footprint is completely different as what's shown here in the survey that you submitted. You're going to need the microphone, but you see that if you look at the survey here, see how this part of the garage steps back?
Right, so that, yes, right, and this is flush.
Correct.
Right.
So obviously, if it was the same garage, it would be flush.
Yeah.
No, I think the front existed and the back had like a little addition on it.
Yeah, so we're assuming that was there when they bought the house.
Correct, but I see in the pictures that you submitted, it doesn't look like that doghouse, that dormer is on it either, so that second story must have been added.
Wasn't here, buddy.
was so young when my parents purchased the house.
Right.
37 years ago.
Yeah.
Yeah, so we're not aware of,
It's just when we see something like this right up against the property line, it becomes, you know, if it
No,
predated
absolutely.
zoning, then obviously this board has to look at it differently than if it was built after.
right. But it was done prior to my clients owning it. I don't know when it was done, the additions.
Okay, thank you.
Yep.
Any more questions, gentlemen? Please?
No, thank you.
Sabrina?
Yes, Madam Chairman. To ensure full compliance with our environmental review, we actually would like to consider information presented by the applicant and any comments from the public before we make a recommendation to the board, so no decision will be made tonight.
All right, let me see if there's any. Is there anyone that would like to be heard on this application? Okay. Hearing none, I'll entertain a motion to close the hearing.
So moved.
All in favor? Aye. Aye. Motion carried. Yeah.
The next case on the agenda is case number 19264, Fred Rook, 5 Fifth Avenue, Smithtown. The location of the property, the north side of Fifth Avenue, 101 feet east of Devon Lane. The property is owned R10. The applicant is requesting a special exception to permit temporary living quarters for a parent, a variance of a special exception standard to increase the floor area from 600 square feet to 808 square feet, to reduce the minimum rear yard setback from 35 feet to 27 feet for a proposed 145 square foot rear first floor addition and proposed 700 square foot rear second floor addition.
Good evening, Madam Chairperson, members of the board. My name is Fred Rook, R-O-O-K. I, along with my wife here, own the property, 5 Fifth Avenue, Smithtown, New York. I'd like to have my architect speak on our behalf.
Fine, thank you. Will you state your name, spell it, and give me your address, please?
Sure. Denise Trifaro, Trifaro, of DTT Designs with Vincent Lucarelli, architect, 1165 Broadway Avenue, Holbrook, New York.
Okay, thank you. You want to tell us why you're here, please?
Yes, we are here because we're proposing a first floor addition, a second floor addition, and a special exception for temporary living quarters for Mrs. Rook's mom. So that portion of the house that will be the addition for her mom is a garage conversion. The existing garage will be converted and built out the back. That's on, if you're looking at the plot plan on the right side, the east side of the house. And it's also a two-story, 808 square foot. So that's where we're asking for the first variance is from 600 square foot that's allowed to an 808 square foot parent living quarters. The other portion is the first floor addition across the rest of the back of the house to increase more modernized flow for the main portion of the house. The back of the house is the only portion that comes too close to the rear property line. So that's where we're on the first floor. The rear yard is what's zoned for 35 feet would be, we're asking for 27 feet. And then the second floor, we're asking for 32 feet. the necessity of bringing her mom, to the house is something that we think is outweighs any of the other implications for these special zoning variances. And it does not affect the neighborhood adversely or the environment from what we can tell. We did receive a letter just this past week, and we've been trying to get in touch with the gentleman who signed it. We haven't received a call back yet, asking for a health department, which we did not believe we needed because we removed one of the existing bedrooms that was on the first floor to make the apartment bedroom for the mom. So it's remaining a 4-bedroom house. It was a 4-bedroom house before. They were also asking about a test hole, which we were unaware that it was on any water line that was, too close to the groundwater. So that's something new to us too. Like I said, we're trying to get in communication with him and have not heard back yet. But we will, of course, comply with any additional applications or test holes that they require. Any questions?
Okay, thank you. Gentlemen, any questions?
No, thank
Blaise?
Madam Chair, the Planning Department reviewed the application and prepared a planning advisory report that all of the members currently have and have reviewed, and we recommended approval of the application.
Okay, thank you. Sabrina?
Yes, Madam Chair. As identified by the Building Department, the current application, due to the temporary living quarters, does require approval from the Department of Health. We need this information in order to complete our environmental review. We have notified the applicant's representatives of their need to contact the Health Department. Additionally, they are located in a high groundwater area, so we will need to see new test hole data within the past 6 months in order for us to proceed with our environmental review. So no decision can be made until those items have been addressed. Thank you. And I'm sorry, our department head is currently traveling, so you just missed him. So, but I'm there if you need to have any other questions. Please reach out to our department.
Okay, we'll do that again tomorrow.
Okay.
Okay, thank you. Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved.
It's been moved and second. All in favor? Aye. Motion carried.
Thank you.
The next case on the agenda is case number 19260, J. Crew, 2050 Jericho Turnpike, Comac. The location of the property is the south side of Jericho Turnpike, 254 feet east of Walter Court. The property is zoned SCB. The applicant is requesting a variance to increase the maximum height of a wall sign from 15 feet to 21 feet for a proposed 17-square-foot wall sign.
Good evening.
Good evening. I'm Michelle Tornatore with Messeri Sign Company. I'm representing J. Crew on this application. Tornatore, T-O-R-N-A-T-O-R-E. Sure. We're,
Do you need a power of attorney?
Do you know whether or not the representative from J. Crew had sent in a power of attorney to allow you to
yeah,
represent them?
yes, I have, there's a power of attorney in the packet. Yeah,
Okay, thank you.
sure.
All right, you want to tell us why you're here, please?
Sure, yeah. So we're requesting relief. We have a sign that needs to be centered on the sign ban area in a well-populated shopping center, Mayfair Shopping Center. It's pretty clear and cut. We can't put the sign anywhere else. If we put it at 15 feet, it would be centered to the awning, which we can't erect it on. So there are other stores at the shopping center that have requested similar variances for their signs. That's all.
Thank you, thanks. Any questions, gentlemen?
No, thank you.
Blaise?
No, thank you.
Sabrina?
No, thank you.
Okay, thank you so much. Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved.
Really moved and second. All in favor? Aye. Motion carried.
The next case on the agenda is case number 19256, Steel Forest LLC, 500 Comac Road, Comac. The location of the property is the east side of Comac Road, 1,080 feet north of Vanderbilt Motor Parkway. The property is zoned LI. The applicant is requesting variances to reduce the required side yard buffer to a residence district from 100 feet to 39 feet, to reduce the required parking setback from 100 feet to 39 feet, to eliminate the required landscape islands for a proposed parking lot expansion.
Good evening, Madam Chair. For the applicant, Brian Kennedy, partner with Forcelli Deegan Tirana, with offices at 100 Motor Parkway. The applicant's before you this evening seeking minor relief related to a parking lot expansion at the site. The proposed parking lot expansion will consist of the construction of 108 previously approved land bank parking stalls along the southern portion of the site and the installation of 111 additional parking stalls. Those additional parking stalls will be located at the north and western portion of the site. Now, the site is currently occupied by a variety of medical tenants, including Stony Brook Medicine and Catholic Health Services. The specialties provided at the site include cardiology, orthopedics, fertility services, radiology, neurology, and primary care. It truly serves as a one-stop shop for medical patients. The only thing missing from this building is an urgent care facility, and the applicant is seeking to convert the space at the northwest corner of the building into an urgent care facility that will serve already existing patients as well as members of the surrounding community. As we all know, a huge portion of patients at any medical facility are infirmed or of advanced age. The goal of the parking lot expansion is twofold. First, to increase the total parking at the site. Now, should this board look favorably on this application, the site will provide a total of 1,385 parking stalls, which will be an increase from the current parking stall calculation of 1,166. Now, the second and more important goal of this expansion is to provide parking closer to the actual building entrances. Patients seeking care at these facilities are often incapable of walking very far. Now, providing those additional stalls, I don't see it up on the screen, along the northern portion will be located in close proximity to the two main entrances along the northern portion of the building. Now, all employee parking will be relocated to the rear of the building to further this goal as well. Now, while we understand that the proposed work will expand into the required buffer along the northern portion of the property, the applicant will still maintain a significant buffer. And that deficiency along the northern portion of the site only impacts a small portion of the site. And while that property that it abuts, 500A Comac Road, is residentially zoned, if you've visited the site or taken a look at it on any aerials, it appears that it is used exclusively for commercial and industrial uses. So along the western portion of the northern boundary, there's a tremendous LIPA easement, so we still comply with the 100-foot buffer adjacent to any of the residential properties along Delaware Avenue. So they should not be impacted by this expansion at all. I can take the board through the 5 town law factors if you'd like. I also have Brian Morell of H2M, the project architect, available, and Kevin Lumpy, the Director of Construction for Steel Equities, available, should this board have any questions. If you don't, I'd ask that you'd look favorably on this application.
Gentlemen, questions?
No, thank you.
No, thank you. Please?
No, thank you.
Sabrina?
No, thank you.
Okay. Is there anyone that would like to be heard on this application? Come up, please. Good evening.
Hi.
May I have your name and will you spell it and your address? please?
Sure.
Sure.
My name is Francine Quinn, last name Quinn, and I live at 39 Delaware Avenue in Comac, just right around the corner from these offices that are looking to expand.
Okay, tell.
So I'm here today because we purchased our home in 2014 when that was formerly a Forest Laboratories building that was there. And we moved from Queens and we came for the quality of living that Suffolk County provides, the quiet neighborhood that we chose to purchase our home in. And although I will say that I am a patient at the Stony Brook offices, I appreciate the work that they do. I'm also in the medical field. Expansion of that parking lot and the hurt that it puts on the quiet for the neighborhood that I'm part of. You're talking about at nighttime, if you wanted to sit out in your yard and, you know, watch the kids catch fireflies, it looks like you're sitting along the back of an airport as far as the lighting. You can see the lighting of the buildings. You can see the lighting of the parking lot lights. There's not a lot of privacy brush or trees that are remaining there. It's very sparse. So unfortunately, some of my other neighbors are unable to make it today, but the frustration that we would feel is that it's really kind of like light pollution that's going to happen because
I don't think that it's going closer to where your houses are.
So it's going.
It looks like, from what I see, it looks like it's getting expanded closer to Comac Road, where the parking lot is several hundred feet further away from you. I believe the buffer, and correct me if I'm wrong, I believe the buffer, as it relates to your neighborhood, is staying exactly the same.
So it's not coming towards that direction. It's going.
They can answer it better, but it doesn't appear that way.
I mean, I'm just here to ask for that, if it's granted, that they just maintain that, add some trees or add something that's evergreen, just so it tends to buffer the light and the sounds that happen a lot better than what's currently there. So respectfully.
Thank you.
All right, thank you
Thank
so
you.
much. Is there anyone else that'd like to be heard?
Good evening, everybody.
May I have your name and address and spell your last name?
Holly, Holly, Moreland, Moreland, Dunn, Dunn. I
Your
just want to
address,
say,
please?
I am the next door neighbor.
Okay.
And we have never had any problems. Not with light, not with sound. It's busy during the day, but it's a busy building. We appreciate the fact that it's there, and we have no problem with them. Are you guys coming up to the fence?
Excuse me,
Or are you leaving
excuse
a
me,
little buffer?
excuse me.
Sorry.
Please address this board.
I just didn't know if they were coming all the way up to the fence, or they were still leaving a little bit of a buffer. So obviously,
Well,
I think they
that's-
said they would.
Okay,
So we have no problem.
okay, thank you so much.
You're welcome.
Okay. You want to come up, please?
To answer Ms. Moreland's question, we are not coming up to the fence. We will still have a 40-foot or 39-foot buffer adjacent to her property. As Mr. Tanzi pointed out to Ms. Quinn, the northwestern portion of the property will still maintain a 100-foot buffer. There will be additional parking stalls installed along that portion, but those were previously approved as land bank parking. As far as light pollution, I mean, town code requires that all light be maintained on site. We will comply with all regulations of the town code. Yep.
Okay, thank you. All right. I'll entertain a motion to close the hearing.
So moved.
We very regularly moved in second. All in favor? Aye. Motion carried.
Adrian.
You want to take a break? All right, we're going to just take a 5-minute break, all right? Thank you.
The next case on the agenda, case number 19262, the Guide Dog Foundation, 371 Middle Country Road, Smithtown. The location of the property is the northwest corner of Jericho Turnpike and 50 Acre Road South. The property is split zone WSI and R10. The applicant is requesting a special exception to permit an animal boarding and kennel facility, a variance of a special exception standard to allow outdoor pens or exercise runs within 100 feet of all property lines and within 200 feet of a residence district. A special exception to permit parking in a residence district, a variance of a special exception standard to allow parking to extend into a residence district more than 50 feet to 280 feet, a variance of a special exception standard to eliminate the densely planted buffer to a residence district, a variance of a special exception standard that requires the buffer to be at least equal to the depth of the extension into the residence district, a variance of a special exception standard that requires conformity with the parking requirements for the district in which the building is located, a variance to reduce the minimum parking from 593 to 235 spaces, to reduce the minimum parking setback on Middle Country Road from 25 feet to 10 feet, to reduce the minimum front yard setback on 50 Acre Road from 50 feet to 40 feet, to reduce the minimum front yard setback on 50 Acre Road from 50 feet to 12 feet for a proposed 6-foot fence, to reduce the minimum front yard setback on Middle Country Road from 50 feet to 10 feet for a proposed 6-foot fence, to reduce the parking building setback to a residence district from 50 feet to 17 feet, to eliminate the required buffer fence and 10-foot densely planted buffer along the residential zoning boundary line, to increase the maximum area of a ground sign from 40 square feet to 216 square feet, to increase the number of ground signs from a maximum of 2 per parcel to 3 for signs G2 and G3, to increase the number of wall signs from a maximum of 1 to 3 signs for signs W2 and W3, to permit a wall sign not to face a public street, wall sign W3, for a proposed 31,950 square foot animal kennel with boarding facility.
Okay.
Thank you,
You're on.
Blaise. Thank you, Blaise. Hi, Brad Hibbert. I'm the Chief Strategy Officer for the Guide Dog Foundation and America's Vet Dogs, just down the road, as most of you probably know. We appreciate the board's consideration of this critical facility project, critical for our future of both of our organizations and the constituencies that we serve. I'll make my comments brief. I just want to give a quick overview of why we need to do this. Guide Dog Foundation, America's Vet Dog, especially over the last 5 years, has really emerged as a world leader in the assistance dog world. We're one of very few schools in the entire world that have a guide dog program and a service dog program. Our service dog program is mostly focused on veterans and first responders, serving them through different disabilities that they might be challenged with in life. Our existing facilities, though, don't match up to those programs anymore. And so we need to look at what we can do not only for our growth, but also for what our future can look like for serving those constituents. We did initiate a national search for alternative locations. I headed that up. It was about a year of exhaustive look to determine whether, when you're going to build a big building, before you start doing that, you better be sure you're where you want to be. And we've made that commitment, and Smithtown has been our home and will remain our home going forward as long as we get what we need to be able to build the building we have in mind. We're proposing just state-of-the-art replacements of existing out-of-date facilities. So this is not anything that has to do with new use. We have built in a modest 25% growth factor that would happen over many years of implementation. The new facilities will be specifically designed to accommodate individuals with visual and physical handicaps. We were originally a guide dog school, and so a lot of what we built wasn't initially with the thinking that we were going to be opening America's Vet Dogs and serving veterans and first responders, which we did in the early 2000s. So if we look at the Puppy Development Center, which we call Phase 1, we're looking at a little bit over a 31,000 square foot, one-story facility. It will have a visitor education lobby. It will also have a multi-purpose room that will be used for training of our dogs, of our students when they're in class. They spend 2 weeks with us here in Smithtown, learning to use their guide or their service dog. Most importantly, enhancing the environment for our puppies and our breeding colony and the moms that we count on. We'll also be able to have our own veterinary suite for our animals in the facility. Right now, we use 3 local veterinarians who rotate on a basis to work with us. We'll also enhance our outdoor exercise areas for the pups and moms, get out and get fresh air and lots of exercise. And we think that when you look at the plans, we think it does add to the beautification of Jericho. Phase 2, which would be plus or minus 5 years from now, would be a 21,000 square foot, one-story facility that would be enhanced for accessibility. Again, our student residence that we have now is not designed with physically disabled veterans and first responders that we're serving now. So the room sizes would accommodate larger beds, adaptive equipment, all the different kind of mobility devices that our veterans use. The goal is to create a functional state-of-the-art environment that supports our clients and all the communities that we serve. Switch it and then more. And so now I'd like to introduce, I'm here with Anna Cho from Studio Myers, and I'd like to introduce our principal architect, George Myers, that can talk to you about any questions you have on the details. Thank you.
My name is George. My name is George Myers, M-I-E-R-S, and Anna Chow, C-H-O-U. We're both partners of Studio Myers Cho Poon. We're from Emeryville, California. And thank you for having us, and I know the hour's late. We prepared a presentation that actually addressed all of, I think it's 18 or 19 of the variances, and we're more than prepared to go through each one. We take them seriously. We could do that, or we could look at any particular one that you have a concern with. Alternatively, we have a 1-minute video walkthrough that might be kind of fun that we'd be glad to show you, or I can answer any questions that you have. I will say this, though. Most of the variances, I believe, are as much a result of the fact that we're not really dealing with just one site here. We're dealing with an entire campus. And so many of the things that we're doing are trying not just to make this a good building, but to actually enhance the overall campus, both parking, landscaping, and just the way buildings and entrances relate to one another. And most of our responses to the individual variances kind of relate to that one idea. How would you like us to proceed?
Yeah, you wanted to do that 1-minute presentation? Did you?
Well,
want to do this?
it's kind of fun. It gives you
Okay.
an idea of the interior of the building, which is obviously not what most of the variances are, but I think it will give you, probably a pretty good idea of the quality of the work that, you should be expecting from this new building.
No signal?
You want to do that, Anna?
Sometimes it loses the...
It's really, video is overblown. It's a walkthrough of the different spaces.
It's not fine, you're not seeing it.
Oh.
It's very nice.
Is it playing? It's not playing.
Should I just turn this
Since there's nobody here, why don't, we'll go low-tech here, and why don't you, can you take it up there?
It's too bad that it doesn't, it's not seeing the laptop for some reason.
It's a while it's not necessarily a public building, it's intended to be an educational experience and very open to the public. And that's kind of the part of the building that this is showing.
Look how cute.
Of course, can't see.
That's all right.
as you're looking at it, one of the things that's important is we're trying to maintain a biosecurity amongst the animals themselves, because these animals, the investment in each one is in excess of $100,000 by the time this is finished. And at that young age, puppies can transfer, different diseases that come in from the outside. So while we've tried to keep the building very transparent, so tours, school groups that would go through the facility can see what's going on, it's done in a way that maintains that security, biosecurity of the individual puppy areas. So I'd be
Right,
glad
I'll
to
ask
answer
gentlemen.
any questions.
Is
you
there
have.
any questions?
I think the only thing that would be important is, could you address the parking that's going to encroach into the residence district, even though it's your property? I imagine there's going to be significant buffers that.
Could you move it in there? The, well,
And we have the plan. so-
Maybe the drawing will get
Yeah.
up. Right now, the parking that serves the campus itself is actually all in the residential area. I mean, in a way, just to be who we are and to have the parking you have. Oh, there you go. Let's see if we can go back a second. Is that the first one? Yeah. So right now, all of the campus parking is actually in the residential area. We are, as part of the overall plan, we're enhancing that somewhat, but the numbers that you see in there that we're providing all take place in basically that same area. So the requirement that comes to, it's hard for me to read those numbers, but comes to something by code of in excess of 500 parking spaces. What we've provided is the actual use by use of all the different campus parts, the admin facility, the student residence, the puppy development. You'll see them in there. And that amount of parking, we believe for the client themselves, and they're very concerned about parking, comes with, when you add in an additional 100 to 150 surge spaces for special events, comes to, I think, something like 235 spaces. I may have that number slightly off. And that is what we're providing in the full master plan. But most of that parking, or almost all, there's not all of the parking, but I'd say 85, 90% of it is taking place in roughly that same area with the red circle that is the existing campus, and that area is zoned residential. But
Correct, but my point was, just for the record, you're going to be providing buffer plantings around that parking.
Oh,
so-
yes.
Okay, thank you.
Yeah, I think, could you put up the one that shows the buffer, that strip? I think several of these, maybe one, right there. This is, for example, I think it's illustrative of, part of the problem. We are requesting a variance because the way the code reads, our building, the new puppy development center and the site it's on technically requires a buffer around it. We actually don't want a buffer between our building and the administration building. We want it to be well landscaped, which is, you can kind of see the extent we're doing with the plaza and the landscaping, but we want to be able to freely have the clients, many of whom are blind or visually disabled, to actually be able to quickly get from the admin building to the puppy development center. So it's a little bit of an oxymoron. Yes, we are asking for that buffer, to eliminate that buffer there, but other areas around the project, along the street, we are enhancing the landscaping, and we very much want that buffer there.
Thank you.
Thank you so much. Right. Blaise, any questions?
No questions, Madam Chair. As the board is aware, planning prepared a planning advisory report.
Right.
After extensive review of the application, we made a recommendation to conditionally approve the application.
I think there's some conditions too.
There are a few conditions, yes. And those conditions primarily will be dealt with during the Board of
With
Site Plan review. Yep.
Okay. Sabrina, anything?
No, thank you.
Okay. Thank you so very much.
Thank you so much.
Somebody in the audience.
Is there anyone who'd like to be heard on this application? Hearing none. I'll entertain a motion to close the hearing.
So moved.
Really moved in second. All in favor?
Aye.
Motion carried. That concludes the hearings for tonight. Thank you so very much. All right, case 19253.
Case 19253, Christopher Riley. I'll make a motion to approve as presented.
All in favor?
Aye.
Aye. Motion carried. 4-0. Case 19254.
Case 19254, Humaira Mahdi. I'll make a motion to approve as presented.
Second.
It's moved in second. All in favor?
Aye.
Aye. Motion carried. 4-0. Case 19255.
Case 19255, I believe it's Wayne and Karen Berbert. I'll make a motion to approve with the condition that the applicant either bring the encroachments into compliance or enter into an agreement with the town of Smithtown.
Okay. I have a second?
Second.
Okay. All in favor?
Aye.
Everyone? Approved with conditions, 4-0. Case 19257, no action.
No action.
Case 19258.
Case 19258, Michael Lally. I'll make a motion to approve as presented with the condition that any damage during the construction of the wall to neighboring parcels be repaired by the applicant.
Okay. Do I have a second? All right, it's moved in second. All in favor?
Aye.
Aye. Motion carried, 4-0. Case 9259.
Case 19259, Lisa Tersalino. I'll make a motion to approve as presented.
It's moved in second. All in favor?
Aye.
Aye. Motion carried, 4-0. Case 19261.
Case 19261, Anthony Sacconi. I'll make a motion to approve as presented.
Moved in second. All in favor?
Aye.
Aye. Motion carried, 4-0. Case 19263, no action. Case 19264, no action. Case 19260.
Case 19260, J. Crew. I'll make a motion to approve as presented.
Regularly moved in second. All in favor?
Aye.
Aye. Motion carried, 4-0. Case 19256. We have another
Secret.
unlisted secret.
Secret.
Okay. Second. All in favor? Aye. Now on the merits?
On the merits, I just had a question. Are buffers are required under the previous site plan?
What do you mean by that?
Well, there were some land banked parking, and he had referenced a buffer, but the neighbor seemed concerned that there wasn't a buffer, but I believe there's currently a buffer there now.
So we can't pull it back up on the screen because we've been having difficulty with the computer. But if you had looked at the site plan, there was a very, very small strip to the west that was being developed, which was part of the land banked parking. So the buffer wasn't being reduced in that area where the houses are. It was being reduced for the land bank parking to actually be constructed. Further, I guess, northwest where the corner of the property actually abuts right on Comac Road. So it wasn't impacting the houses. There are other residentially zoned properties in that area, but they're used I guess, for like commercial purposes.
So it looked as though there was that portion that was being developed to the northwest, but there was also one row of parking along the entire north property line.
Right.
That was previously approved as land bank
Yes.
land banked parking.
Land bank
And I guess my only question would be is, I don't want to put or I wouldn't suggest a condition on there to add additional buffer if there was a buffer contemplated in the first previous approval.
Well, when the land banked parking was approved with the original approval, in essence, the land bank parking, until constructed, actually becomes part of the buffer.
Right.
So if you remove that buffer to construct the parking, then you're losing some of that buffer. But I guess you have to really look at it and ask yourself, what is it that you're buffering, and is it really going to help?
So yes, along that north property line, east of the parcel that you're talking about that is commercially used,
Right.
even though it's residentially zoned, appears to be commercially used, that entire strip butts up right to the backyard of all of those houses on that.
Right, but I guess, can you grab?
It was on that site plan.
It was on the site plan, yeah, but it's a very, very narrow strip.
Of parking.
For the parking.
Yes.
Yes. So you're really not losing a lot of buffer. I don't know if it would really pay to,
Yeah, I just didn't want to approve it and then all of a sudden the buffer that they thought was there that's really not there.
right.
You want to see the photos too?
No, you can pick it up in the site plan. Here, you want to see, Liz? So if you look. Yeah, so if you look, Liz, to the,
So that's what's being impacted.
right, this is the new, right, this is the residences here.
Literally one row of spaces.
And there'll still be a 100-foot buffer from the previous site plan. At least that's what it indicates here.
It looks like it's going to be roughly 100 feet, yeah.
Okay, so then we'll just leave it up to the Board of Site Plan Review.
So, yeah, that's fine.
Okay. All right, so case, we did the seeker already?
Yes, we did. Now on the
Case
merits.
19256 on the merits, I'll make a motion to approve as presented.
It's regularly moved and seconded. All in favor?
Aye.
Aye. Motion carried 4-0. Case 19262.
Case 19262, Secra.
Second. It's regularly moved and seconded. All in favor?
Aye.
Aye.
Aye. Now on the merits.
On the merits, we have PAR on this one. I guess I'll read the approval into the record. For the special exception to permit animal boarding and kennel in the WSI zoning district, approved with conditions. Variance of a special exception standard to allow outdoor pens or exercise runs within 100 feet of all property lines and within 200 feet of a residence district be approved. Special exception to permit parking in a residence district be approved. Variance of a special exception standard to allow parking to extend into a residence district more than 50 feet to 280 feet be approved. Variance of a special exception standard to eliminate the densely planted buffer to a residence district be approved. Variance of a special exception standard that requires the buffer to be equal to or greater than the depth of the extension into the residence district be approved. Variance of a special exception standard that requires conformity with the parking requirements for the district in which the building is located be approved. Variance to reduce the minimum required parking from 593 to 235 spaces be approved with conditions. Variance to reduce the minimum parking setback along Middle Country Road from 25 feet to 10 feet be approved with conditions. Variance to reduce the minimum front yard setback on 50-acre road from 50 feet to 40 feet be approved. Variance to reduce the minimum front yard setback on 50-acre road from 50 feet to 12 feet for a proposed 6-foot fence be approved with conditions. Variance to reduce the minimum front yard setback on Middle Country Road from 50 feet to 10 feet for a proposed 6-foot fence be approved with conditions. Variance to reduce the setback of a building to a residence district from 50 feet to 17 feet be approved. Variance to eliminate the required buffer fence and 10-foot densely planted buffer along a residential zoning boundary line be approved. Variance to increase the max area of a ground sign from 40 feet to 260 square feet be approved with conditions. Variance to increase the number of ground signs from a max of 2 to 3 per parcel for signs G2 and G3 be approved. Variance to increase the number of wall signs from a maximum of 1 to 3 for signs W2 and W3 be approved. And variance to permit a wall sign not to face a public street for sign W3 be approved. And the conditions are as follows. 1, parking stalls shall be constructed or land banked as required by the Board of Site Plan Review. 2, fencing and landscaping screening shall be subject to review by Board of Site Plan Review. And 3, the proposed architectural design, materials, and landscaping shall be subject to review and approval of the Board of Site Plan Review.
All right, do we have a second, please? All in favor?
Aye.
Motion carried, 4-0.
All right.
Okay.
This one.
Okay, the next case is case 13562, Patelli Enterprises. I believe everyone has received the findings of fact
Yes.
and have read them.
Yes.
Can I have a motion to approve the findings of fact, please?
I'll make a motion to approve the findings of fact for case number 13562.
And I have a second? Okay, all in favor?
Aye.
Of that? All right, I'm going to ask that all the findings be entered into the record. All right, now I need a motion on that case, please.
Case 13562, I'll make a motion to deny.
Okay, do I have a second? Second. It's really moved in second to deny, all in favor?
Aye.
Aye.
Motion carried, thank you.
We're doing the extension of time?
Want to do this extension of time? Sure. Do I have me back? Blaise, you want to go over the extension of time? Is there a problem there?
No, there is not.
Okay. All right, case 18823. I need a motion to approve the extension of time.
So moved.
Riley moved in second. All in favor?
Aye.
Aye. Motion carried for the extension, 4-0.
Madam Chair, the next case, 19160, I need to recuse myself for this application, or this decision, so I will be leaving.
Okay, thank you.
Just let the record reflect that Member Tandy is leaving the building and going home for the night and not participating in the application.
It's going to take me a minute to pack my stuff.
It's fine.
Good night, all.
Good night. Okay. Case 19160, Tansy Properties. I believe that there was findings of fact. Everyone has read them? John, Bill, and I?
Yes.
Yes, we all have read them. All right, I'll need a motion to approve the findings of fact, please.
You have to do secret first, Adrian.
It is secret, oh, it's unlisted, secret. I'll need a motion to. Okay, John, you want to read this, please? The secret? John, could you read that, please, into the record?
Read it out loud?
Yeah. Mhm. You want
I
my
got-
mic?
No, it's all right, I got it. Comply with the State Environmental Quality Review Act set forth in Title VI, Part of 617 of the Official Compliance Code Rules and Regulations of the State of New York. Upon review of the environmental assessment form submitted on this appeal and the CCAR recommendation memorandum issued by the Town Department of Waterworks and Environmental dated March 5th, 2025, I hereby make a motion for the board to establish itself as the lead agency pursuant to CCAR regulations. Determine that the application construes an unlisted action. Pursuant to the CCAR regulations, determine that this application, construes to the unlisted action under CCAR regulations that will not result in any significant adverse environmental impact, and issue the CCAR negative declaration determination of non-significance for the applicants pursuant to CCAR regulations. Motion to vote on the application. On appeal number 19160, I hereby make a motion to adopt the notice and decision of the finding of facts of this board, which grants in part relief requests subject to the conditions set forth therein.
Okay, I'll make a motion. Do I have a second?
Second.
All in favor?
Aye.
All right. All right. I need a motion now for the findings of fact, please. I need a motion to
Motion.
adopt the findings of fact.
Adopt findings.
Do I have a second? Second. All right, it's readily moved in second. All in favor?
Aye.
Aye. I'm going to ask you to enter the findings of fact into the record. All right? Now I need a motion. To approve. Mhm. Can I have a motion? Can you make a motion on case?
Make a motion on 19160 for approval.
Yeah. Okay. Do I have a second? It's really moved in second. All in favor?
Aye.
Aye. Motion carried, 3-0. Am I okay? We're good. Okay.
Just making sure.
Okay. That concludes our hearing for tonight.